start asking really hard.
Good afternoon. My name's Allison. I am the finance chair for the summit. The summit is a student-led, adventure, and we are entirely funded by sponsors. So I just wanted to give a special thanks to Joan Swanson, who is a very generous and ongoing sponsor that helps us make sure that this happens every year. We have a few members from Joan Swanson here today, so I just wanted to let them know that we're very, very grateful for their support, and I'm going to hand it over to them. Thank you.
Good afternoon. My name is Bessie Doshbach. I manage the environmental law practice at Jones, Swanson, Hedell, and Garrison. And I have the distinct privilege this afternoon of introducing you to three of my favorite lawyers. Tad Bartlett is my partner. He runs our appellate practice and has been instrumental in the success of many of our commercial and environmental cases over the last several years. Rock Palermo, at the end, is a partner with Viron, Bice, Palermo, and Wilson in Lake Charles. Rock has a long and successful history in maritime, personal injury, commercial litigation, and, of course, oil and gas legacy lawsuits. And finally, Professor Rob Verchick, who is, of course, the chair of environmental law at Loyola and also heads up the Tulane Disaster Relief Leadership Program. Those are really just the highlights on these gentlemen's credentials. We could spend all afternoon talking about their stellar records, but we have a lot of substance to get to today, so I'm going to leave it at that. Rock and Tad and I have been co-counsel in the litigation captioned the Southeast Louisiana Flood Protection Authority East versus Tennessee Gas Pipeline Company case that we filed in the summer of 2012. For those of you familiar with that case, you'll know that it's the case on behalf of the SLFPA against, at this point, the total is of somewhere around 80-plus oil, gas, and pipeline companies. The SLFPA has sued those companies for their role in the coastal erosion in the buffer zone that provides flood protection against the levees and flood protection assets that the SLFPA oversees. For those of you who follow the case, you'll know that on February 13th, Judge Brown in the United States District Court for the Eastern District of Louisiana granted defendants motions to dismiss that case, and that the week after, we as counsel for the SLFPA filed a notice of appeal taking that decision up to the Fifth Circuit. In a nutshell, the Eastern District's opinion concluded that the oil, gas, and pipeline companies that were sued in the case owe no duty to the public. Tad will take us first through the reasons why we think the court got it wrong, why those defendants do indeed owe a duty to the SLFPA, and most importantly, why we think this case is a far cry from the Barasich case on which the court relied so heavily. Following that, Professor Verchick will give us a stronger understanding of the design and intent behind the regulations governing the defendant's activities, which we believe inform not only the standard of care for those activities, but also, therefore, defendants' duties to the public and, of course, to the SLFPA. And finally, Rock will walk us through some examples of what it looks like when oil, gas, and pipeline companies are derelict in their duties and obligations to landowners and to the public at large, and why we think the opinion from the Eastern District is an important one for an understanding of what defendants are responsible for, not only to the Louisiana citizens, landowners, and public, but maybe across the United States where oil, gas, and pipeline companies operate. So without any further ado, I'm going to turn it over to Tad. We have until 5:45, so if anybody has any questions, please ask them. I have some for these gentlemen, but I can assure you that they would most like to hear from you. So, Tad?
Thanks, Bessie. And I think what we're each going to do is try to give you a complete nutshell, if I can say that, so that we have time for questions and interaction with everyone, because we know that there are a lot of sort of questions of public importance related to this case. So I'm going to go straight into the Friday the 13th dismissal that we just underwent. And I think it's important to understand, first of all, what was in front of the district court, in front of Judge Brown. As Bessie said, that the point when the dismissal order was issued, there were 88 defendants in the case. There were a number of motions to dismiss. There were a group of pipeline defendants that we call the Natural Gas Act defendants that filed their own motion to dismiss, raising preemption issues. A large group of 60-something defendants joined in these joint motions, and they filed 3 different motions to dismiss. The first one raised preemption issues under federal law, but also raised the issue of standing, which was the one jurisdictional issue raised by the defendants. And that standing argument was based on Louisiana Act 544 from last year, which I'm sure many of you may be familiar with if you followed the case. Because that doesn't come up in Judge Brown's ruling, I'm not going to talk about 544 in my presentation, but obviously if you have questions about where those issues stand when we get to the question and answer period, I'd be glad to address that. In addition, the joint defendants, the large group of defendants' motions to dismiss raised issues of applicability of the public service doctrine, which essentially gets to whether or not public agencies or public bodies can recover costs for doing their job, and the argument there being that the levee board is empowered to build levees and provide flood protection services, and if their damages are that that costs more, is that a recoverable cost? They also raised, the defendants raised issues of non-justiciability under the primary jurisdiction doctrine, which gets to the question of whether the courts have a say in issues that have been predominantly granted to the jurisdiction of particular federal agencies. And then, of course, there were a number of issues they raised as 12b6 motions to dismiss for lack of a cause of action. And that's the one motion that Judge Brown and the district court looked to. She didn't look at all to the jurisdictional issue of standing, which leads us to believe that she implies that she found that there was standing and that Act 544 didn't apply. The reason we know this is because a court can't turn to merits issues if it doesn't have jurisdiction. Now, she doesn't mention Act 544, and she doesn't mention the standing issues in her opinion, but that she reaches beyond those issues to the merits under the 12b6 motion, it's really the only conclusion that we're left with. She didn't touch the preemption issues, she didn't touch the public service doctrine, and she didn't touch the primary jurisdiction doctrine issues. Instead, she just turned to the 12b6 issues, which, as Bessie said, turns primarily on this question of duty. Now, the duty question comes up at the heart of the negligence action, the 2315 action. But the duty analysis that the district court made really flows through her analysis of all the causes of action. It comes in as part of the third-party beneficiary analysis that she makes under the contract claim. It comes in really as part of the causal proximity analysis under the natural servitude of drain claim, which is another claim that's got just huge amounts of things we could say about, but we actually had a whole panel last year here about the natural servitude of drain claim, so I'm not going to revisit that, although again, if you have questions later about that, I'm sure we'd all be glad to talk about it. But essentially, the issue that's at the heart of Judge Brown's decision is this question of duty. Now, under Louisiana law, and this was a state law cause of action that was involved here, even though she kept jurisdiction under federal question when she denied her motion to remand, she acknowledged these were state law claims, but they had substantial entanglements of federal issues in them, which is going to be another issue that will likely be revisited in the appeal. But under Louisiana state law, when you're looking at questions of duty, you have to do a sophisticated analysis usually based on ease of association. And that looks at the question of whether the harms that the plaintiff is alleging are within the scope of, or there's an easy association between those harms and the duty that's alleged that the defendants have. Rather than engaging in this ease of association analysis, though, the district court articulated essentially a per se standard, an automatic standard that the oil companies don't have a duty to repair the damage that they've caused to the coast. And she took this from an earlier decision, a 2006 decision by Judge Vance in the Eastern District of Louisiana called Barasich, which we're going to look at in a little bit more detail in a few slides. But Judge Brown first brought this up in her order denying the remand motion, where she said there's no duty under state law, so I'm going to look to federal law to define the duties. And what she says in the dismissal order is, this court has already opined that oil and gas companies do not have a duty under Louisiana law to protect members of the public from the results of coastal erosion allegedly caused by pipeline operators that were physically and proximately remote from plaintiffs or their property. And so she dropped a footnote from that to the Barasich opinion, signaling that she sees the Barasich result as an automatic rule regarding duty for coastal wetlands damages. And so she turned then from the question of whether there's a duty under state law, and Judge Brown in the dismissal order looked to whether there are duties created by federal law, and really then turning kind of away from the issue, because the way that federal law gets used in the state law duty analysis is to help define the scope of the standard of care. It doesn't establish the duty. It's important to remember that the duty is established under Louisiana law in a tort situation by Article 2315 under the Civil Code. It is not a federally derived duty, but it can be a federally sort of defined standard of care. So what the Friday the 13th opinion sets up is kind of an issue of duty in the coast. I think about it kind of like Beauty and the Beast. Is there a duty for these coastal restoration damages? And for Judge Brown, it all comes down to Barasich. And the first quote I have up here from the Barasich decision, I think is probably where Judge Brown is looking to, where Judge Vance wrote in Barasich, "For plaintiffs to recover in this matter, they must demonstrate as a matter of law that defendants had a duty to these hundreds of thousands of plaintiffs to protect them from the results of coastal erosion allegedly caused by operators that were physically and proximately remote from plaintiffs or their property." And I think that's what Judge Brown was looking to, because you see the repeat of that language of physical and proximate remoteness. One thing that the Barasich court also said, though, in conclusion, and this is not language that Judge Brown has repeated or made any acknowledgement of in her decision, the Barasich court essentially says this is not an automatic rule applied to all coastal restoration issues, because Judge Vance concluded by saying, by all accounts, coastal erosion is a serious problem in South Louisiana. If plaintiffs are right about the defendant's contribution to this development, perhaps a more focused, less ambitious lawsuit between parties who are proximate in time and space, and these are the tests then that we're going to have to start to look at, with a less attenuated connection between the defendant's conduct and the plaintiff's loss, would be the way to test their theory. So the Barasich court itself acknowledges that there is a case out there that can articulate these duties, and that can test these duties and can get past this dismissal stage. So just a quick refresher then on the basic facts on why we think this SLFPA suit does meet this test that was established at the end of Barasich. Recall that SLFPA, our client, is this very defined, geographically contiguous jurisdiction on the east bank of the Mississippi River, with a very defined mission to the protection of the territory within that jurisdiction from overflow. And then the focus of the case is what we've defined as the buffer zone, which is this wetlands area that is directly contiguous to the jurisdictional territory of SLFPA. Within that buffer zone, we've identified through review of permits, pipeline rights-of-ways, and various other documentation, exactly the activities by the defendants within the buffer zone. And so just by looking at the style of the complaint, comparing the SLFPA suit to the Barasich suit, you can see that the SLFPA suit was brought by this individual board with a defined mission, not by a general class of plaintiffs, which is going to be, I think, key in looking at the distinction between what the Barasich court rejected and what it said was still possible. And then it was brought against a defined number of defendants that had been identified by specific activities that they had taken within this buffer zone that is contiguous to the territory of SLFPA. Then the work that went into identifying those defendants and their specific activities was contained within the complaint. The complaint attached several exhibits that had, I think, the Wells' spreadsheet was a 66-page spreadsheet. I mean, there's pages and pages identifying exactly what activity and what location within the buffer zone was taken by each defendant. And when you compare that against Barisic, see, Barisic was a class action, so brought by an indefinite number of private plaintiffs with widely differing damages. They were spread across, the plaintiff class was defined as including anyone who sustained injuries within a 17-parish area. The defendants were an undefined number of defendants within 2 defendant classes whose activities weren't confined to that 17-parish area, but basically any defendants within those classes who caused injuries that could be said to have been experienced by those plaintiffs within the 17-parish area. And with that situation, the Barisic court said, and this seems like a fairly logical result, plaintiffs do not allege that the actions of any particular defendant were a substantial factor in causing the injury suffered by any particular plaintiff. Now compare that against what I showed you in the SLIFPA lawsuit and the spreadsheets identifying exactly which actions were at issue by the defendants. Nor do they assert a causal connection linking a particular defendant's operations to a particular plaintiff's injury. Plaintiffs do not dispute this in the Barisic case. Rather, they point to allegations that all of the defendant's activities caused all of the plaintiff's damages. Again, not the case with what was alleged in the SLIFPA suit. The plaintiffs number in the hundreds of thousands, and they live in 17 parishes across South Louisiana. The defendants' conduct took place in different areas of South Louisiana at different times over the course of several decades. If you held up the petition that had been filed in Barisic, it was a little thicker than this, maybe not as thick as this. The petition and the attached exhibits in the SLIFPA lawsuit, about like that?
Like a phone book, yeah.
Yeah.
A big phone book.
So there's a great difference in the detail involved. And then there's a great difference in the territory that was involved. As you recall from the Barisic language that was picked up by Judge Brown in our dismissal, there was a concern with the sort of territorial contiguity. When you look at the colored area right there in the very middle of this image, you see who the plaintiff was in the geographical area where the injuries are experienced in the SLIFPA situation. All the white part, everything else that's shaded in, that's the Barisic plaintiffs. So it's a very different situation, we would argue, and we alleged in the lawsuit. And recall on 12b-6, that's what matters. It's what we alleged in the lawsuit, not necessarily it wasn't a question of proof at that point. So instead of looking at any of those distinctions, the district court, in dismissing us on Friday the 13th, treated this Barisic situation, which is very different, as an automatic rule that no duty applied was owed by oil companies for doing the damage that they've done in the coastal zone. Our argument, as you can see, I think it flows pretty easily from the allegations, and the distinction between the allegations in SLIFPA versus those in Barisic is that Barisic does not create this default rule. And that instead the court should have engaged in, and hopefully the Fifth Circuit will engage in, this more sophisticated ease of association analysis. And like I said, that looks at what the defendant's duty is, how it derives. It looks at who the plaintiff is and how they were harmed, and sort of what the defendant's knowledge is, and where all of that comes together, you've got this ease of association. Is there an association that can easily be made between the harms that SLIFPA is alleging, the harm to their ability to engage in flood protection, and the damage that was caused, and the duties that the oil companies had to not impair the effectiveness of the levees? And I'm not going to get into detail on each of these circles here because I'm trying not to use up everybody else's time. But these were issues that were briefed to the district court that were not part of the decision and will be part of the briefing in the Fifth Circuit as well, and again can be part of our answers to questions at the end. Just sort of the logistics of where we are now. The decision came out on February 13th dismissing us. We filed a notice of appeal on February 20th after receiving authorization from SLIFPA's board president. The record should be completely lodged in the Fifth Circuit by the middle of March, and a briefing notice will be issued to the parties by the end of March. Our experience is then that briefing will be completed likely by the middle of June. Oral argument should be then set usually 3 months later, so September or October, and within 60 days, typically, the Fifth Circuit will have a decision. So likely by the end of the year, we'll know where the Fifth Circuit comes out on these issues. And one thing I've heard a lot of in sort of people's comments and to the press since the February 13th decision is that, the Fifth Circuit is this impossible mountain to climb in an environmental case. And I think it's something easy to think and something easy to, say when you practice in this area and you practice in this, area of the country and you practice in this area of the law. But I think when you look at it, it's kind of a myth, this myth of the hostile Fifth Circuit. Every year, the Fifth Circuit's clerk's office releases this report of judicial workload statistics and cases and reversal rates. And going through the most recent one, for cases in which the Fifth Circuit orders oral argument, which we feel is likely going to be given in a case of the magnitude of this one, 33.7% of the time, just as kind of a statistical baseline, the Fifth Circuit either vacates or reverses, at least in part, opinions that have been ordered for oral argument. Now, like I said, this is just a statistical baseline. It doesn't take into account the substantive merits of a case. We'd like to think we have better than a 33.7% chance just because of the merits of the argument, but I don't want to talk about that right now, but just is the Fifth Circuit actually inherently this brick wall that we're going to run into? And we don't think it is. And I think there's a good example of that, which in another high-profile litigation pitting government agencies and private plaintiffs against the large oil industry interest from the BP Macondo oil spill, there have been 13 times that the sort of basic heart of that litigation, different pieces of it, have been presented to the Fifth Circuit in the last couple of years. And I'm not counting all the kind of spin-off investor derivative actions and insurance actions, but just sort of the heart of the litigation there. 11 of those 13 times, the Fifth Circuit has ruled in favor of the private plaintiffs or the government agencies. 3 of those were denials of en banc rehearing of opinions, and those decisions actually allow you to see which judges of the active duty judges are voting for en banc hearing or against en banc hearing. All 3 times they voted against an en banc rehearing of a decision that went in favor of the plaintiff or the government. And on 8-5, 2 of those were on 8-5 splits and 1 was on a 7-6 split. So we feel comfortable that this is not a court at the Fifth Circuit that just refuses to hear these kinds of arguments in these kinds of cases and to look at the merits of them. So I think that's the end of where I have, just sort of for a nutshell background of what happened, why we think it happened, and what the road is from here, and what the place looks like that we're driving to. So, Bessie.
Thank you, Tad. And I think, I'm sure we have a lot of burning questions, but we'll just run through our presentations, if that's okay. So with that, I'll turn it over to Rob.
Hi, thanks. It's great to be here. Today, what I want to talk about, I've been reading over and over again this decision since it came out. When did Friday the 13th? Friday the 13th. And
oh, you don't have one that's yours?
Yeah.
Can I?
Oh, you keep the picture up.
Can I leave a picture up? Okay.
Yeah.
Fine with me. That's okay.
Nice big salt scar.
And I've been looking at this case, as Bessie pointed out, from the point of view of what I'll say the point of view of federalism, from the relationship between state government and federal government. And there is actually a really interesting issue involving the federal level and the state level in this case. And I just wanted to talk a little bit about it because the more I read this case, the odder it seems. And it's odd whether or not you like the outcome or not, I think. It's odd in the way that it's put together, and I thought I might talk a little bit about that. What's interesting about this, as Tad points out, is that this case originated in the state court with all state claims, all private claims under the Civil Code. And so under normal situations, you would expect that's where you would go if you had a claim of all state claims. And it is true that there are some federal statutes, which I'll talk a little bit about, that inform perhaps what the meaning of some of these state provisions might mean. And so what happened when the case was removed and the federal court accepted it and then denied a motion to send it back down to the state court, the federal court was essentially saying, and this is perfectly fine, that as an institution, that the federal courts have some kind of expertise, some kind of advantage in solving this problem, and so that's why we're going to keep it. All right. Usually that's because there's a federal claim involved, and that might create precedent that other federal courts might want to follow, this sort of thing. Well, that's fine. This case didn't quite have that, right, because there's no precedent that would be set, because the only precedent that the only time other federal courts would care about what this court says is on a question that has to do with an outcome related to a federal statute. And we don't have that in this case. We only have state claims. So you might say, all right, well then maybe what the institutional expertise is that a federal judge is much more likely to understand and be able to resolve questions of federal law, which is perfectly understandable. And so you might think, at least what I thought when I saw this going forward, is that this is going to be a case that's billed as a federal judge reaching an outcome by making some tough inquiries about what the federal law means. And what happens when you read this case, at least when I look at it, is it seems to me that it's almost all pivoting on tough decisions made about state law, and almost nothing pivots on any strong interrogation of the federal law. So let me kind of explain what this might mean. So the easy way to figure it out, because not everybody's a lawyer, and even the law students sometimes probably want a break. So the way to think of it, picture me riding on my bicycle. I'm at an intersection, a car hits me. I'm okay, I recover, but I have really expensive hospital bills. And so I want to find out what happened. And it turns out that the driver of the car's brakes failed, and the brakes failed because they were not inspected correctly by the manufacturer. So I want to sue the manufacturer of the car for not properly inspecting the brakes during manufacturing, and I do that in state court, and I do it under the state provision 2315, right, which says that there's that if you act in an unreasonable way and you're a tort freezer, you create harm to me, that you're liable. Now, in the course of litigating that, I might discover that the manufacturer of the car actually violated a regulation from the Department of Transportation that required how brake inspections are supposed to go. All right? Now that's good for me, because my job is to prove that the car manufacturer acted in an unreasonable way, and now I can say that, well, we know it's unreasonable because the car manufacturer was actually not even complying with these federal regulations. Okay, that's different from saying that a federal law has been violated. That's just saying they did something unreasonable under the state law. They're not supposed to do things that are unreasonable. I can show you it's unreasonable because I got evidence about the DOT. All right? What would not happen in a case like that is that the federal court would get involved and say, I want that case because it involves the interpretation of a Department of Transportation regulation. That would not happen. Now, it might happen that the Department of Transportation might itself make an investigation and maybe fine the manufacturer under some sort of federal law. But the idea that you would have to remove that case, the idea that you could never sue a car manufacturer in state court because it's inevitably going to involve a DOT regulation, is odd. Is odd, right? But that's essentially what happens in this case, and what happens when the judge looks at the case and makes the decision that there's no duty. She's interpreting state law. She's looking at the state law and she's reading it, and she says tortfeasors are liable under the article for, quote, any damage remotely caused by his or her fault. Any damage caused by his or her fault. Now, Tad's right that there's this whole other product that we have to think about, this ease of association doctrine that the state courts have built to explain when something has been unreasonable enough and when it's affected somebody in a way that's proximate enough that we say it's wrong. So I was riding my bicycle. I didn't buy that car. I don't even like the make of that car. I don't know the owner of the car. I'm just a member of the public who's owed a duty, right? And the duty I'm owed is that people who manufacture cars and sell them in commerce in a way that might end up in Louisiana have to care about people like me, right? So the question really for the judge in this case is, does that state law create some kind of a duty, and if it does, what is the standard by which we judge the unreasonableness? And that's when the plaintiffs want to come in and say, oh, well, if you want to know what's unreasonable, you should look at the Clean Water Act, the Coastal Zone Management Act, and the Rivers and Harbors Act, all federal statutes, to give you some inkling of what unreasonable looks like, at least in the eyes of Congress, right? And so that's the idea behind it. Now, what's interesting about this, and I promise I'll get to the federal part in just a second, but one of the things that Judge Brown says is she does say, oh, we don't think there's a duty for oil and gas companies to protect the public from erosion. And she does cite Barasich, another federal court case interpreting Louisiana law. But what she says is, I really have to look at Barasich, essentially, because there's no other Louisiana law out there. The Supreme Court of the state of Louisiana hasn't actually said anything on this particular issue. So I'm adrift. I don't have any guidance. And I have to make what she calls an eerie guess, which is what lawyers call this idea when a federal court is trying to guess what a state court would say its law means. So here's the situation. The judge who said this case is more federal than state and needs to be in a federal court is now saying, I don't have enough information about what state law means, so I have to look at an earlier federal court to help me out. And so, without saying whether you think Barasich is right or whether it's wrong, Judge Brown, or whether she's interpreting Barasich correctly or not, she's borrowing from another federal court judge's opinion about what Louisiana law means because there is no other way to find out. Now, another way to find out might have been to let the case stay in state court and let state judges figure out what the law means, and if there's an appeal, let it go all the way up to state Supreme Court, and then the state Supreme Court could say what Louisiana law means without having to have a federal judge guess about it. All right. So what you might be saying, though, and what I was saying was I was reading the opinion, I said, okay, I get that, but there's also a federal side, and the federal court has special expertise in understanding and reviewing federal matters, and so maybe this case is really going to come down to some special, interesting investigation of federal law. And so what the court says is, I can't say whether there's a duty or an unreasonableness about all this because the Supreme Court of the state hasn't spoken, so I'm going to have to look at the federal statutes instead. And she looks at the Clean Water Act provisions, which is where the wetlands permitting program is nested. She looks in the Rivers and Harbors Act, a very old statute, which has to do with preserving navigational channels in the United States, and also has to do with dredging and canals, and which is also a permit process. And then she looks at something called the Coastal Zone Management Act, which is another federal law, which encourages coastal states like Louisiana to maintain special state programs and also permit programs. And the basic allegation that plaintiffs are making is, if you take the facts as given, their argument is these permits issued under all three of these federal statutes have in various ways been violated, and that has harmed the public, including the plaintiff in this case. And so what the judge says is, these federal statutes, they're not intended to protect the public, they're intended to protect other entities. And so the court says the Rivers and Harbors Act, for instance, which is designed to protect navigation, she says that's mainly to protect the federal government. All right? And that the Coastal Zone Management Act exists mainly to protect states. Now, lawyers, we get into these fictions, so sometimes you really can say, yeah, we're protecting the country without protecting you, or we're protecting the state without protecting you, right? And we buy that. I mean, there is a way to make that kind of analysis. But the plaintiffs in this case were arguing that those statutes actually were written with an eye toward the public. So how would you figure out whether those statutes were written with an eye toward protecting people like you and me? Well, usually what courts do is they read the text of the statute, they look at it within the structure of the statute, and then they read about the purpose of the statute. And if it looks, with all of that stuff together, that these statutes exist to protect real individual people like you and me, then we would say, okay, it exists to provide some kind of a duty, if you will, or at least to promote the welfare of the general public. So what the judge does is something slightly different from that. The court looks particularly at the Rivers and Harbors Act and says, I don't see any other case within my jurisdiction that has ever said there's a duty owed to the public. And so I will assume there isn't. And then the court looks at the Coastal Zone Management Act and says, there is no precedent that I have seen anywhere else in which a court says there's a duty owed to the public. So I will assume there isn't. This is a kind of passive way of making a decision when you don't want to go into or don't think you can go into the details yourself. Courts normally, when there's no precedent, courts usually don't say, I can't deal with it. When there's no precedent, courts usually say, I'm up for it. I'm going to read this statute. I'm a federal judge. I'm going to look at the structure of the act. I'm going to read the history of the act. I'm going to buy a book, whatever it is, and I'm going to come up with what I think the best answer is. You would expect someone not to do that if they felt that they actually didn't have the expertise or didn't have the institutional power to say very much about it. But this is a federal court that said, I want this case because I have special federal superpowers that will enable me to read these statutes in ways that are more definitive than other people. And yet what happens is the court is looking at the statutes and says, I don't see any guidance from any other federal judges, so I must conclude that there is no directive. I'm going to sum up, but you can go on Google and in 5 minutes find enough legislative material and statutory material to at least make a case that there is a public duty under each of these statutes. I went to Wikipedia, but as a law professor, I would prefer that you went to other sources. But what you'll find, and I know this from my high school days, is or my college and law school days, if you go to the Rivers and Harbors Act, you will find that there is no way a permit can be issued without what is called a public interest review process. And in fact, permits have to be made conditional if to do otherwise would violate the public interest requirement. All right? So that suggests that the Rivers and Harbors Act is more than it doesn't say the United States interest, right? It says the public interest. And if you actually do look into the history of this, what you'll find is there was a lot of private navigation that really relied on this stuff, and that's what the thing is. If you look at the CZMA, you'll find in the very beginning it says the CZMA, the Coastal Zone Management Act, exists in order to help the nation's coast and oceans, including the Great Lakes, and to see that they are healthy and thriving for this and for succeeding generations. For this and succeeding generations. So that's not this and succeeding states. right? It's this and succeeding generations. And if you look at the permit program under the CZMA, you'll also see there's something very close to what I would call a public interest review process, in which there's notice and comment, and people get to say, this is how this would affect me individually. The Clean Water Act is a much easier one, actually, in this way, because it's much newer than the Rivers and Harbors Act, and it was very explicit in the reading. And I tell my students everybody has memorized this, that the purpose of the Clean Water Act is to preserve the chemical, physical, biological integrity of the nation's waters. And then it goes on to say wetlands, too. So if it's written for anybody, it's written for the waters and the wetlands. But you know it's for the people because the Clean Water Act actually provides a citizen suit provision that allows any person who's been harmed by a violation of the Clean Water Act to come into court. So my point, my point is not so much about the outcome of this case, although there's enough to debate about that. It's just really the process. And what seems to me is very odd is that this is a case, it seems to me, that must turn on the meaning of state law. Must turn on the meaning of what is reasonableness and what is duty when we're talking about the oil and gas industry and erosion of wetlands. There's no question in my mind about that. It's a question of state law. What's very odd about this is that the federal court apparently knew that and apparently bases the opinion on what the meaning of state law is, but without any state law precedent to enable a better situation. And then by looking at federal law in a way, I think, that seems very passive and incurious. And I don't know why that is. I don't know why it sort of appears that way, but that's just my first look at it. And I would suspect that if this, when it goes to the Fifth Circuit, that one of the things the federal judges there should be encouraged to do is to take a much closer look at the meaning of what the federal law means, as well as thinking about how to get these issues before state courts so the real legal issues can be examined. Thanks.
Wow, thank you, Rob. So insightful. I'm sure we will be having many, many more conversations on these subjects as we're working through our briefs.
I took notes.
Good, because I was going to take the notebook. With that, I'm going to turn it over to Rock to give us a little insight into what it looks like when defendants ignore most, if not all, of their obligations under these regulations and other applicable areas of the law.
Thanks, Bessie. I'm going to probably, because of my eyes, I'm going to go down here because I can't see that screen. They've talked to you about the Flood Protection Authority's lawsuit. A lot of what both Jones Swanson's firm and my firm do is do what's called legacy litigation. And legacy litigation, the term legacy, there was two sides of the coin of how people refer to that. One was that the oil companies said that these properties were handed down from landowner to their kids, their grandkids, so forth. And so that legacy, by the time the grandkids or great-grandkids got the property and their royalty payments were lower, they filed suit against the oil company for land contamination. The Supreme Court, however, saw it a different way, and they said that the legacy actually comes from the oil company's bad practices, the legacy they left in their bad practices that harmed the land. So those are both sides of the issue, and I'll try and give you both sides because it's important to know whether you're defending these cases or on the plaintiff's side, what the issues are and how these things come up. What you see on the screen is a picture of what we call a salt scar. And this is a case. I've changed the names a bit just so, even though the case was tried, I changed the name just so we'll stay friendly with everybody. So it was in Catahoula Parish. That's an area where between Natchez and Alexandria, thereabouts. And this is what happens when brine, which is a byproduct of oil-field drilling, things come out of the ground when you poke a hole in it. There's gas, and there's this brine that you can't really do anything with. You either truck it off, inject it back down into an injection well below the water zone, or you just put it in a pit. Unfortunately, for many years, they put these things in a pit, and you get, this is what it leaves. And it may not, you may say, well, that looks nice. It looks like Destin or something. But it's stuff will never grow there. And we'll get to that more later. Brine, it's far more saltier than the ocean. So it's a particular problem, especially in Louisiana, because we were the last state to outlaw pits. We didn't do it till the late 70s, even get started with it. Many states had done it, outlawed them much earlier than that. So let's just talk about, this is kind of a garden variety legacy case. And so it was fairly simple. It was tried in a couple of weeks. So we'll go through it. The property, as I said, in Catawba Parish, 250 acres of farmland, used as farmland, cotton, beans, corn. And this is where it is. This is going to kind of be although, are you talking after me or not? Okay, so I can take my time since we'll have a lot of questions, one of the two. Mid-Level Oil Company is the company that was one of the companies that were sued. We sued, you saw the initial slide had Sam Spears, and what you find in a lot of these cases is that in the early days, the big oil companies, the Shell, the Exxons, they picked the low-hanging fruit. And when they got rid of that, they started handling it to mid-level operators. And then when they got through, they handled it to fly-by-night operators. And so the call him Jim Jones or Sam Spears or whatever, the fly-by-night guy, he's nowhere to be found. And if he does, he doesn't have anything at all. And so we run into those problems. But Mid-Level Oil Company had it during the time it was making producing a lot of the oil and gas, and they leased it in 1960. And they always call these things different names of fields, and it's Boatner's Break Field. So a typical oil and gas mineral lease, say typical, there's really not one, you see this is what's called a bath farm, which is Bath was the printer. That's why they call them bath farms. But anyway, most of the stuff's already written, and the landman goes and knocks on the door, and he gets the person to sign it, tells him he's going to give him, whatever for the royalty. This is signed in June 1960. There's the close-up of the field. And here's what the property looked like in 1959. And in all of these cases, aerial photos are our best friend because they tell us when the property was first developed, where they put the pits, where we can even tell, and you'll see in a second, which way the wind was blowing and where there's all pooled on it. But in any event, the aerial photographs tell us what the damage was and when was it done, because in many cases you have a timeline that stretches for literally 60, 70 years, and you have to find out, well, which one of these guys really started the problem, or how many of them participated in the problem. And you can do that by looking at these aerial photographs and seeing, first, this is what it looks like today. This is what it looked like in 59. But what I was saying is you can look at those aerial photographs and start seeing where the pits are, when they started developing. It's almost like a very long time-lapse photograph. Luckily, the USDA and forestry were doing flyovers of this area of the country back in the late 40s and 50s. And so that they provide, through present time, but they provide a very important piece of evidence when you go back on these cases that you're looking at evidence literally that was, in some instances, 80 years ago or so. So, as I told you, here's what it looks like today. At the time of trial, this is what it looked like. Sadly, and this trial was probably about 3 years ago, sadly, it still looks like that. And we'll get to, even though we won, we'll get to why that's the case. So, more pictures, and this is just to show you. This stuff is like a fine salt dust kind of material. And you can see that, even there's really nothing grows. I mean, here you can see where they tried to maybe make something grow, put a little plot, and they try with the most. Bermuda grass is the most thing that they'll try and see if it grows, and nothing grows. And this is not the original pit. We'll get to it later, but this is due to the fact that this stuff seeps and migrates and goes out. So what may have started with a 100 by 200 pit now is the size of a 200 feet, 100 by 200 feet pit, migrates out, and it's now as big as a football field or so. And that's just, like my law partner says, the tip of the iceberg, because when it seeps and goes down, then it goes down laterally and deeper, and then you may have as many as hundreds of acres of water below this groundwater that becomes affected over time. So how did it get this way? I went through a little bit. Mid-level operated the lease, produced lots of oil and gas. It assigned its interest to another company, and then also that company assigned its interest to Three Rivers. You're always looking at different operators and what they did. Three Rivers assigned it to Sam Spears Jr. Spears abandoned the lease, abandoned pretty much life. In fact, we found him, I think, in Mississippi, and was not. He was, let's just call it, retired. Now, the problem you have is, in this case, the wells. All those operators just kept leaving the stuff, and so the wells were not properly plugged and abandoned because Sam Spears was the last guy on the list. And the state has what's known as an orphan well program, and maybe some of you in here can tell us how many orphan wells the state of Louisiana is tracking right now, but the number is crazy. There's a big long spreadsheet. I was asked one time to actually go find it, and I did, and they prioritize them, and even the ones that were the worst priorities, like near a school and a water tower, weren't being properly plugged and abandoned. So as a state, we're behind in many things, and this is one of them. So this is just one little part we often find is part and parcel with the legacy that the oil company leave behind. So the well produced 1.3 million barrels of brine during mid-levels operations, 1960 to 1973. It was producing over 90% brine by no later than 1965. In South Louisiana especially, or Louisiana, this area of the country, it's not uncommon for wells and later in their lives to produce 90 to 95% brine. And all companies will continue to operate those wells knowing that 10% or 5% is better than nothing, better than dry hole, but they got to do something with that brine. And it's a lot. It's a lot of stuff. There's another well drilled. It was a dry hole. And what companies do and what is legal to do and is a best practice, whether we can argue whether it's really a best practice or not, is to convert a dry hole into a saltwater disposal well. And so they'll take that well that they didn't get all out of and then re-inject the brine. Instead of having to truck it off, which is expensive, they say, well, let's just keep it local. We'll put it back where hopefully it came from, below the water supply, and everything is going to be good. And that works well if the well was drilled well, it didn't have well and drilled properly. It did not have holes where the salt water could leak into the groundwater. It didn't have gaps, was properly cemented, all the things that need to happen so that you have a really good well that you can call a proper disposal well. In any event, they converted it to a saltwater disposal well in 1966. There's a third well drilled in 61, 665,000 barrels of brine, and this well was a little bit better on the all versus brine side, 65%, and so that means old math, 35% was all. So during the operations, all those wells produced about 2 million barrels of brine. That's a lot of brine. And there's ways to calculate this because they have to report this to the state. One thing is great about when you're doing these cases, and what's really incredible is what we find in the documents. These oil companies record everything very nicely, and they send it in the state. They also report when they really screw up, and they write it down. And the culture was at the time, and you'll see it maybe even some of these documents in this case, I can't remember, but we'll see. They're almost, the culture was, you know, we're going to write down that we screwed up here and we caused a big problem, and, you know, it's not a big deal because nobody's going to come get us. We're not going to get in trouble about it. You know, it's just an economic thing we're documenting here because, you know, we missed out maybe on some oil, and so what if we, you know, had this problem that caused some pollution? It really didn't do any harm, or at the time they didn't think it did any harm. But you'll see they should have known better. So mid-level did not use that injection well it had there. Instead of using it as it was intended to be used, they kept doing a couple of things. They either dumped the brine into unlined pits, which seeped into the soil and groundwater, or they allowed the brine to overflow onto the surface of the property, or they discharged the brine in nearby waterways. And so when we look at these aerial photographs sometimes, we'll see where we have this dead vegetation, and we'll see that it kind of continues. There's even more of it that goes down a little ditch into a canal, and so you get where, because of brine being a fluid, it just goes to the lowest points. Either it seeps into the ground in the groundwater, or it just goes all over the property and damages the property for a long period of time. Now, they didn't, as I said, quit using the unlined pits after it installed the injection well. They continued to store the brine in the pits, and the brine continued to seep from the unlined pits into the soil and the groundwater. The main pit was 150 feet by 175 feet and at least 4 foot deep. It had an approximate storage volume of 18,000 barrels of brine. Now you remember, you had 18,000 barrels of brine as a storage area, and you remember the numbers I went through is how much brine it was producing. So there wasn't any evidence of anybody trucking anything off. So that stuff just seeped and leaked into the ground and to the groundwater. So here's what the main pit looked like, and in this case, you can see you actually see some crude, the wind's blowing out of the northwest and pulling that all in the southeast corner, and that's what it looked like in 1972. So it made a mess, and it didn't do anything to clean it up. And that's the case in about every one of our hundreds of cases that our firms and other firms do. The companies walk away from it, and then when it comes time to clean up, they first say, well, wasn't us. If it was us, we didn't know that, one, you're too late, you sued us too late. Prescription 3, if it was us and you're on time, it really didn't do any damage because you know, nobody's using the groundwater right now. You know, we may have ruined the groundwater, but nobody's using it there's no houses out here. It's just farmland. So, you know, you can truck some water in to water your crops or get it from a nearby river or something like that. But don't worry about the groundwater because, you know, nobody's using it as in a household or anything. So we don't need to fix it. Or they will say, you really can't prove it was our brine that contaminated the salt water aquifer. In fact, we can go back to, you know, thousands of years where there was an ancient river that ran through here, and it was known to have salt in it. They will even use, if you know this area of the state, has lakes that are called, there's a lake called Saline Lake, Saline Bayou, a few things like that. Now, granted, all those bodies of water are completely fresh, have white perch in them. But they will say, well, there must be evidence of, the reason why they called those things that is because it was just naturally salty in that area. So you really can't prove that it was us. Luckily, we prevail most of the time on that, but that's the kind of arguments you're faced with. We generally have the theme, clean up your own mess. Robert Fulgham, who was a minister, wrote this book, and he had some basic advice, some basic rules that could guide anyone, even a kindergartner, to lead a happy life, and one of those is clean up your own mess. Interestingly, this is from a BP station here. When you're on their property, follow the rules. So everyone knew it was wrong. We'll get to that in a second. This is what's really great is the oil companies spend a lot of money on research. And in fact, if you watch the Masters golf tournament, you see them in white lab coats, like curing cancer or something. I think they spend actually more money on those commercials than they do on curing cancer. But they have what's called the American Petroleum Institute. And the American Petroleum Institute, API, is based in D.C., and they get the best and the brightest from the oil companies to write about what they can do better. And they try. I'll give them that. The guys that write this stuff are well-intentioned. When it gets down to the guys that have to spend the money to do the right stuff, it's a little different story sometimes. So this is written in Pampa, Texas in I think this is 1932. It's called Division of Production, Division Waste. Now, 1932, you can imagine we didn't have email, we didn't have fax machines, and the oil companies will say, well, this was out of Pampa, Texas. It must have not have it wasn't widely distributed. And these people were still going to API in D.C. and having these caucuses. They act like we were back in the Stone Age. They used the defense, well, this didn't get disseminated. That generally fails too, as you'll see in a second. So the API says we're only kidding ourselves when we think that we can dispose of salt water by solar evaporation from earthen ponds. What we have attributed to evaporation was due to seepage. They said we had this pond and we thought it was just going up and God was taken away and everything was going to be okay, but it wasn't. It was seeping. And he says eventually such seepage may either follow an impervious stratum to the surface, where it may affect vegetation, or may find its way to freshwater sources, either surface or subsurface, and in such quantities as to be objectionable. Kind of a nice way of saying people are going to get pissed. And they did. And they do. Because when you ruin somebody's water supply and they're a farmer, you can't fix it. You just can't fix it. Or if you ruin their acreage, you can't get that back. And every farmable acre is very important to a farmer. So this is, we take corporate depositions, whether it's federal court 30v6 or state court 1442 depositions of the corporate representative. Change the name here. And so we asked him, you're aware that the use of unlined pits is a hazard for the storage of brine? Yes. And the reason is because unlined pits seep and leak, and the brine penetrates in the surrounding soil and groundwater, correct? Answer, yes. And that's been known in the industry in Louisiana for many, many years. Answer, quite a few, yeah. In any event, the hazards associated with unlined pits have been well known and experienced oil field operators for many years, correct? Correct. Now, remember, this guy is a mid-level owner of an oil company, and so, they're kind of stuck. They can't claim ignorance and also be the big oil guy on the block. And so he nicely admits to it. And the main hazard is that they create a salt contamination in the surrounding soil and groundwater. Answer, yes. So the The head of the oil company knows it. Their own petroleum engineer says it's wrong. His name is Charles Moffitt. And so I asked him, are you aware that mid-level testified that it was aware that the use of unlined pits is a hazard, so forth? Yes, he showed me that. I asked him, you agree with that? He says, yes. Can't hardly disagree with the guy that's paying him, but sometimes that happens. So, and I asked him, are you aware that these facts were known by the industry for many years? Yeah. So despite this, rather than installing a proper disposal system in the beginning, it dumped hundreds of thousands of barrels of brine into the pits on the property. Now this happens, this is one case, but we can tell you 1,000 stories like this all over the state where this same thing occurs. So importantly, in 1965, they knew that the pit was leaking. They get a letter. Well, actually, it's the letter from, I've changed his name, so it's the mid-level guy to Mr. O.B. Mobley in July 1965. He said, we've inspected the surface location of our number 2 Boatner, which is the dry hole north of Discovery Well, and find that it is covered by approximately 4 inches of salt water. As you know, we have received a call, because this was a complaint he had gotten, he's responded to, from the Tensas Basin Levee Board advising that they will proceed with a cease and desist order on our producing wells unless we immediately take steps to correct the salt water situation in this field. Well, the last thing an oil company guy wants to hear is that he's going to have to cease and desist from the stuff that's making his money. So he's now, and this is an emergency to him. The money, we're going to shut down the oil if you don't do something about this. So what they do? They continue to use the unlined pits, even though they knew better. And so now, in 1969, they get a letter from the Department of Conservation. And this is a common deal. It said the documents say a lot, either from the state or from the Tensas Levee Board or from a neighbor or whatever. It says representatives of the Inspection Enforcement Division surveyed the production facilities in the above-mentioned field and noted the following items which are not in line with the regulations set forth in Statewide Order 29B. Statewide Order 29B is the, I won't call it commandment, that's too strong of a word. It's the guidance for oil companies on what they have to do when they have an oil field operation. Everything from how a well gets drilled to how they're supposed to leave it when they're through. So they say there's no retaining wall around the stock tanks to prevent spillage that occurs in everyday operations resulting in pollution. Our agent reports that the lease is equipped with a saltwater disposal pit and a disposal well. And at the time of this injection, he reports that the fluid level in said pit was above ground level and seepage was occurring through the surrounding levee. Attached here too is a copy of his color photograph. We usually don't get color photographs in these cases because they're too old, and we don't get them. We don't get a state inspector who, on his own, documents it. For that to happen, it's got to be really bad. In fact, this is the only case where I had a state inspector take a photograph of a escaping brine. It must have, I don't know if he stayed on the job long or where they got him from, but God bless him, he took a photograph of it. Not a good photograph, but at least it doesn't show up well. But anyway, it looks bad on my screen, and you can come look at it later. But he took a photograph of it, thank God. So we have contaminated property in just 6 years of mid-levels operations. Here's the 1966 aerial photo. Again, we got that northeast wind pulling the oil in the northwest wind pulling in the southeast corner. General Honorary's going to get mad at me here in a second if I get a compass setting wrong. 1972 aerial photo. So what did they say after looking at the contamination? You always, whether it's a car accident or anything else, you said, did my client do anything to contribute to this? In this case, you ask him, do you know of anything else that could have caused this besides produce brine? He gave a truthful answer. No, I don't. That's what it does. It's what's really not funny, but it's sad. The industry views this as, yeah, I did it. But we all did it. So they use the "we all did it" excuse, and everybody was doing it. And it's just salt water is the other thing you hear. So it's really hard sometimes, even for a jury, to the defense calls it salt water, and they'll say that even they'll pull a bottle of water and they'll find some sodium in it and say it's just a matter of degree. So you're faced with all those types of hogwash defenses when you try these cases. So in this case, what was undisputed, it was contaminated, that they caused the contamination, and the time frame was important because of the number of operators you're dealing with. That timeline, they were responsible for it because you can pin how much brine they produced and the contamination using the overhead flyover photographs. So in this case, the mineral lease, that bath form I showed you earlier, it contained no specific restoration clause. Many leases will say to original condition or all damages. Those would be the good ones. Some say we're only responsible for the trees we cut down to get to our site or something like that. There's lots of cases where the landowner was not terribly sophisticated. The landman took advantage of that, and the leases did not require much restoration at all. In this case, or absent a contract provision, the standard is where the lessee is operated unreasonably or excessively. As in this case, the lessee has the obligation to correct the damage due to the unreasonable or excessive operations. That comes from Marine versus Exxon, a recent case. So we would argue correct the damage means original condition. They say correct the damage means regulatory. Now remember, you've been here, some of you, I guess Friday, you probably heard many times that Louisiana does not have the best reputation in writing laws that protect the earth, the ground, the land, the state, the resources. And so it's all a matter of degree. And so if the regulatory says, well, you only have to restore to a level that will grow Bermuda grass to down to 3 feet, well, they could have, if nobody's using the groundwater, if it's not usable groundwater being used at the time, then you don't have to clean up it either. Well, the restoration is not going to be that big of a requirement either. So we'll get to what happened in this case in just a second. So that's what we're dealing with. And we have experts, we have opposing experts, and for example, our expert says that if you're going to do everything, correct the groundwater, you're going to get that huge salt score and really excavate it all, carry off the dirt, do all what you need to do to make it where it's right before oil and gas operations put a footprint on there. It's going to cost $57 million because you're going to have to, and the biggest cost in this is generally the pumping and treating of the groundwater. And they do that in Texas all the time. They do that all other places. In Louisiana, they act like when you cross the border, the technology is they can't truck it here or something. That's the defense of it anyway. So in all these cases, just like anything, if I spill something, if I clean it up right away, it doesn't cost much time and energy. If you wait decades after you do something of this nature, it costs a lot of money. So the graph of cost and time, the longer you wait, the more it's going to cost. It's just natural. So our expert was Mr. Araby. Their expert was Mr. Lahaye. And basically the differences between the cleanup models was that the defense uses this phrase monitored natural attenuation. You break it down, it means you watch and you look and you do nothing. So that's what we're faced with. And, you retest. You go back and you keep testing and make sure it's not worse. Well, it's just going to spread. The numbers may not go up. It's just going to stay the same or get worse. So this is Mr. Levee. My colleague is questioning him that you're not claiming that your proposal will clean up all the oil-field contamination on this property. He says, right, my proposal does not propose to remediate 100%. Okay, in fact, you don't claim that your proposal will restore this property to its pre-oil and gas state, correct? He agrees, no, not to its pre-oil and gas state. So, in all these cases you're faced with, and you look at it, why hasn't anyone done anything? You get to these sites and no one has done the first thing to try and clean it up because people just walk away from it. They say this is the way we do things. Everybody does it. The landowner got his money for his oil and his gas, and he didn't complain at the time. Well, most of the cases you don't see this effect until years later, or this marked effect, as you saw in the historical photos. But the biggest reason is because it costs money to do it right. When you make this kind of mess, it costs a lot of money to fix it. And interestingly, these people are real up front that it's not in their interest to do it the right way. I've never had it this easy explained to me before, but I give you, they had this meeting, so I'm deposing their petroleum engineer. He says, maybe I asked you this before. I apologize. Who else was in the meeting that day? Jay Levee, that environmental expert. Joe, Jim, those are the oil company guys. Some other people. Question, I don't want to talk, I don't want you to tell me what Mr. Wilson, the lawyer, discussed with you, but tell me the discussions between or among you, Mr. Levee, and Mr. Burton. Answer, we were looking at what was the least expensive way that we could clean up the damaged area. I asked him what was the opinion. I wasn't privy to that. They were going to submit the report, and I've not seen it. Question, but the goal was to get the least expensive way to clean it up. Answer, right. Well, they have this stuff, I'll call it pixie dust, but it's, they put a chemical on a chemical and hope it goes away, lessens the brine or the sodium there, and it takes about forever for it to work, if it works. So it's really not useful. It doesn't work on especially something this big. And what's nice is even the API says you don't use it in pits. You don't use the chemical amendment remediation. Gypsum, you put gypsum on it. I call it pixie dust because that's what they actually think it's going to work, and it never does. But they keep selling it, So anyway, at the end, any of these oil companies, the choice is you do it right and you keep the property clean, or you do it cheaply and either you make a mess and continue to make a mess by not cleaning it up right. And as you saw, even to the day of trial, they are saying it costs too much to do it right. We're going to do it the least expensive way. That's what we're trying to do. So that's a typical case. In this case, the judge awarded. He kind of had bought the DNR, Department of Natural Resources model for cleanup. At the time this case was tried, one of the first cases had gone before the DNR star chamber that is composed of DNR regulators who say what really needs to be cleaned up to satisfy regulations. And the thought that DNR had was, we're just going to make you clean it up to plow depth, which is about 3 feet deep. Well, what happens, especially in this area of the country, where the soils are have a lot of clay, and they have a high water table, that it rains and whatever's down there, the brine's down there 20, 30 feet down, it's just going to bring it right back up to the surface. So even if you cleaned it up to plow depth, one rainy season later, it's going to be right back where it started. So it's not a very scientific or logical way of doing things, but that's what DNR put out there. This judge thought that that made sense. The proof's in the pudding. The property, the property still looks like that today. If you were to Google Earth or fly over it or drive to it, even though they've tried all the things that Mr. Lahaye said was going to work, none of it's worked, even though they only are having to clean up to 3 feet. So that's the part of the problem is the culture, and you'll hear more about that, I'm sure, later from General Honore, and you may have heard it already before, is that we have protected an industry like no other industry has been protected. We make laws especially for them. They in fact, in testifying before the legislature last year, I said, why don't you just be honest with everybody and amend Article 2315 and just put at the end, except for all companies. You know, just cut to the chase. Instead of having all these rules and amendments to different parts of the law that at the end means they do less or do next to nothing, let's just do what you're trying to do. Just take them out of the equation and let them have their way. So I'll stop now. I think we probably have about 5 minutes left to ask questions amongst any of us at this time. Thank you.
Thank you, Rock. I think that just to put a cap on this, on our panel and open up to questions, whether it's your garden variety legacy case, like Rock and Tad and I have a lot of experience with, or the SLFPA case, the themes are the same, that the oil and gas companies have known what their obligations are. They have known when they have been derelict in those obligations, and they also know the consequences of those of not following through on those obligations. And we've had the opportunity to make that record in a number of cases, and we're all looking forward to a positive result in the Fifth Circuit so we can make that record on behalf of the SLFPA. So with that, we do have a few minutes for questions, if anybody has any. Right here in the front.
2 levy questions. One, had your trial judge been a state court judge before she became a federal judge? And 2, did she allow oral argument before ruling on your motion?
Yeah, on your first question, she had not been a judge prior to her appointment to the federal court. She had been a litigator for a number of years. She was the city attorney for a few years. Yeah. And then she got the appointment to the federal bench. We did have oral argument. She actually had oral argument on 2 days, one day just on the motions to dismiss, and another day we had brought an offensive summary judgment motion on Act 544, and she held oral argument on that. I think those were like November 12th and December 10th. And then, of course, her opinion came out on February 13th. So fairly quick and timely order after those arguments. We just think missing some of the finer points.
In the back?
What damages were pled in y'all's petition for the levy board?
You want to do that?
Yeah, I'll take that. So the damages pled were the damages for the increased cost of providing flood protection as a consequence of the loss of the buffer zone, which enables the system, the levees and the flood protection assets to function to a 100-year standard. There is that includes maintenance, operation, rehab, also construction cost share, and then also specifically in our petition we did plead for injunctive relief, which would be the restoration component not of the flood assets but of the wetlands.
So economic losses for the levy board?
Economic losses for the levy board, yes. Anybody else? Oh, over here.
Quickie, I seem to remember the Fifth Circuit had a case called Comer or Murphy Oil, where it was kind of a creative theory in the Fifth Circuit on bond.
The Comer case, is that the one you referenced? Yeah. Go ahead.
Yeah, you know, that Comer traveled a very interesting path through the federal courts. The district court in the Southern District of Mississippi, Comer is a case brought essentially about greenhouse gas emissions, and their role was I might be. I don't want to get too deep into it because, well, anyway, the Southern District of Mississippi said this was a political question, not justiciable. We're going to dismiss it. The Fifth Circuit, in a panel opinion, reversed the Southern District of Mississippi and said, no, this needs to go forward. Then there was a vote by the Fifth Circuit to take Comer en banc, which immediately vacated the panel opinion. Before they had the en banc rehearing, I think one of the judges maybe retired. They no longer, I think they ended up with a tie vote, essentially, which meant nothing.
Oh,
they didn't have a quorum.
There's no quorum. Yeah, they lost one.
That's it. That's it. So they had taken the vote already to take it en banc, which vacated the district court, vacated the panel opinion, and ended up with nothing in its place. So it just remained reversed.
But a very interesting case, because the panel opinion in finding that there was a duty on behalf of these defendants who had been responsible for these emissions, finding there was a duty to the plaintiffs. So a case that we were familiar with early on, and we're counting on to at least stand for something in terms of how the Fifth Circuit will think about these issues.
Even though technically it doesn't exist anymore.
Right.
Somebody ought to write a little case note on that one day, because I'm still the trivia question of how a case can just go away when you have an en banc and they don't have a quorum. You would think that the three-judge panel ruling would stay. Instead, it just goes poof. I find that it's strange that they didn't have a quorum, and if that's the rule, that's a heck of a way to make a case go away, is just have some people not make it to the en banc for quorum. But anyway, that's a rule I didn't know until recently.
There's an argument it may be a violation of due process, if you think about it, not to have an available appellate body.
Right. Which court do you make that argument in?
Well, that's...
We've got one more question over here, I think, at least.
I think this is an example of the pixie dust working the opinion of a legacy question. How do you overcome limitations or prescriptions?
The contract language, the contract prescription is 10 years, and so there needs to be activity, oil and gas activity on the property within 10 years. So that's your, if there's not, then you don't, unless they really, did something strange where you do a contra non volentem. But the tort claims, which we do bring in cases where we notice it within a year, sometimes those stick, sometimes they don't. So, we really concentrate on the contractual provisions, hopefully giving us the all damages provision or original condition or something like that.
I would add that the Marine decision gives some pretty good insight into how courts view what is knowledge sufficient to excite attention in the context of legacy cases. And Rock's right; the contract claims are generally that's going to be your fallback. But we do bring the tort claims, and we do fight hard through the prescription issues, and we win them often, more often than I think lawyers who are not practicing in a legacy context would think. I think there was a question over here. I didn't want to miss you.
This is a question for Mr. Palermo. Did you guys conduct a norm survey at that site?
At that site, norm, we do it some, and it comes up in the testing, the water testing. Generally, norm was not an issue at that site of any significance. It is in some, not in that one, in my recollection. If it would have been, you would have seen it in the slideshow.
Here we go. Yeah.
Real quick memory check. On the Comer, wasn't there a motion to the Supremes for a supervisory writ, and they didn't grant cert to hear it?
I don't recall, but is that right?
I think there was an attempt to get the Supremes to order the Fifth to do something, and the Supremes denied the cert. Right. So it was like auxiliary pixie dust. The Supremes had a chance to issue an order, and they decided not to.
Noted. Thank you. Anybody else? I think we were till 5:45, and
our time's up.
We've got. Okay. All right.